30 minutes ago, the Supreme Court's conservative majority ruling that a Christian graphic artist who wants to design wedding websites can refuse to work with same-sex couples. The court ruled 6-3 for designer Lorie Smith, despite a Colorado law that bars discrimination based on sexual orientation, race, gender, and other characteristics. Smith had argued that the law violates her free speech rights. I do want to bring in Dan Urman, a professor over at Northeastern School of Law and School of Public Policy, to talk a little bit more about that case. Thank you so much for taking the time to be here.
My pleasure. Good morning.
Good morning. So first off, your thoughts here on this ruling coming down and what it really means.
So it is pretty unsurprising. As you mentioned in your lead-in, it's a 6-3 ruling. We have a 6-3 supermajority on the court, and they have been pretty dead set at offering religious or speech exemptions from laws. So even though this was a speech case, they sort of framed it as conscience or freedom of association. And I think you're going to see future challenges to these anti-discrimination laws where people say, you can't force me to do this. So this was a big victory. And in some ways, you could say that it is pushing back at some of the Supreme Court's earlier pro-LGBT rulings, like Obergefell back in 2015 for same-sex marriage, because this involves people who want to celebrate a same-sex marriage and a business can refuse them.
Is it surprising that they waited until essentially the end of the session here to release this one? Because it seems like for the most part they kind of wait until the end to release the more controversial opinions.
Well, this is an example where I take the justices at their word, which means they're finished when they're finished. You are totally right that the controversial cases take longer, but that's because of the process. They go back and forth, sending drafts back and forth. If you read yesterday's affirmative action opinion, they were almost taking direct shots at each other. And that's because of the norm at the court where they share their drafts with each other and they kind of always have the last word. So the reason you see it is it's the product of maybe 10, 15, 20 drafts. So what I'm saying is they're not slow walking them. They're trying to basically respond to each other. And then finally they say, okay, I'm done. Let's print it.
So could this case, I guess, lead to some similar cases in the near future? Could this just be kind of the start of, I don't know if you'd want to say a pattern, if precedent being set? Could we see more of these cases?
Oh, absolutely, right? Because so much of what we do is expressive, right? So the notion here was that this designer did not want to make it look like she supported same-sex marriage. But Josh, so much of what we do is expressive, right? What if you are a caterer? What if you're a photographer? What if you're a florist and you say making flowers is expressive? So do you see how this can lead to other challenges to laws that make you serve everyone?
All right, and here just moments ago, the Supreme Court now striking down Biden's plan to wipe away $400 billion in student loan debt. That information just coming in. We were waiting on that ruling all throughout the morning here. Can you kind of break down for me the case itself when you're talking about student loan debt and really what the question was here?
Right. So the question here is whether President Biden, and by the way, thank you for breaking the news to me. I'm downloading it just like everyone else. The question is, can President Biden use what is called the HEROES Act to basically cancel and eliminate student debt for borrowers who had types of federal and federal adjacent loans? And it looks like the court said no, Biden exceeded his authority to do this.
Is this a decision that we would have expected here? Because we know that Biden's plan has been fairly controversial overall. Is this what we expected to happen? And again, this is, of course, essentially the last day that those opinions are being released.
They are ready to go on summer vacation. Yes, this is what we expected, Josh. If you listen to oral argument, you could hear real skepticism from 5 or 6 of the justices. Their concern was that Biden was kind of stretching what was called the HEROES Act, which was pausing payment on student loans during emergencies. And most people, myself included, said, I don't think that this student loan forgiveness is going to stand. And here we are. It's been struck down.
What will be the overall impact of this ruling here? Will it have a real impact in America for, let's say, former students who have quite a bit of debt?
So I think the impact will be huge, and like everything else, we'll get a better sense of it over time. So first, the Biden administration was ready for this, Josh. They actually are now creating a 90-day grace period. In other words, they realize this was probably going to happen, and they want people to know that they're not going to have to pay immediately when they resume the billing. Number 2 is the political question, Josh. I mean, is Biden going to say to the country, I tried to waive debt, and this conservative Supreme Court is keeping me from doing it? Vote for me if you want to change the court or if you want policies like this, right? So I think in a way he can run against the court. So maybe he's not that upset with the ruling in that regard. But for students, not to trivialize it at all, yes, a lot of them thought that they were having debt waived, and now the bill collectors are coming back.
Is there a future where the court does revisit this plan, or at this point is it just gone?
So great question. I mean, I think the ball is really in Congress's court, Josh. They could absolutely write a new bill that basically turns into law what Biden attempted to do. So I would say it's really, in that regard, up to Congress. The other option is that the Biden administration could use what's called the Higher Education Act from 1965. So this is another provision where they could waive the debt. They used kind of an emergency shortcut called the HEROES Act. So that's the other option, but that takes time. And for people who owe money on their loans, they're going to have bills come due before Biden would finalize that rule.
Is there anything else that you want to add about the loan forgiveness plan before we move on to talking just a little bit more about affirmative action?
Well, I guess my take on the loan forgiveness plan is that to me, it does illustrate our polarized society where these were things Congress used to always take care of, right? In some ways, we are living under government by judiciary because Congress is so gridlocked. Now we have a narrow Republican majority in the House, narrow Democratic majority in the Senate. So we're not going to see major laws get passed like something that would solve this issue.
All right. So I do also want to talk, because you are essentially our Supreme Court expert at this point, want to talk a little bit more about the ruling from yesterday with affirmative action. Can you kind of break down what happened there and what the outcome was? It sounds like that was the decision at this point that most legal experts were expecting would happen.
Yes, and I keep talking about oral argument. Oral argument for this case was on Halloween. I was a much younger man back then, and it was 5.5 hours. And if you listened to oral argument back in late October, Josh, you had a sense that at least 5, probably 6 justices were uncomfortable with the way that colleges and universities use race. So in their opinion, they basically said colleges and universities can only use race in very narrow circumstances, and the way that Harvard and UNC did violates the Equal Protection Clause of the Constitution. So they have forbid Harvard and UNC from officially using race for race's sake.
Will there be an immediate impact that is felt by this? I spoke with a legal expert yesterday when the ruling came down, and he said colleges and universities will be, quote unquote, scrambling at this point. What will the effect be immediately?
So you're absolutely right that they're scrambling, but I will note that all colleges and universities, including their general counsels, have been working on plans since Halloween, because that's what you do. They will be looking for what are called race-neutral alternatives. What does that mean? That basically means top percentage of high school classes, geography, zip codes, other ways to achieve diversity, because colleges and universities want to be diverse, but now they cannot officially use race, so they can look for secondary measures. And I do think that means that the numbers of underrepresented minorities at the selective colleges and universities will go down, at least in the short term.
All right. Thank you so much for taking the time to be here, Dan. We appreciate it. And, you're great at helping to kind of break all this stuff down for us. Really quickly, I do want to kind of read the basics here once again, as a sharply divided Supreme Court did rule today that the Biden administration overstepped its authority in trying to cancel or reduce student loans for millions of Americans. The 6-3 decision, with conservative justices in the majority, effectively killed the $400 billion plan announced by President Biden last year and left borrowers on the hook for repayments that are expected to resume by late summer. The court held that the administration needs Congress's endorsement before undertaking such a costly program. The majority rejected arguments that a bipartisan 2003 law dealing with student loans provided the authority that Biden claimed. Dan, is there anything about this that is surprising to you, or anything else that you want to mention before I do let you go?
So that is what I really would have predicted for that case. Big picture, now that this Supreme Court term is coming to a close, is that it was more conservative overall with the cases, but there were two that were somewhat surprising, and I guess you could say more moderate. One of those involved the redistricting in Alabama, and the other involved what's called the independent state legislature in North Carolina. And in those cases, John Roberts and Brett Kavanaugh joined the liberals for a more moderate opinion that has to do with voting and drawing of districts. Other than that, it was a solid set of wins for the conservative supermajority.
Do you see that very often, where you have, let's say, a conservative judge that does rule with a more liberal justice, or is that just something, you kind of said it surprised you a little bit?
It does happen, but John Roberts, in addition to being a justice, is the Chief Justice, and he cares a lot about the court being perceived as legitimate. He doesn't want to look like a partisan hack, if you will. So what's a good way to not look like a partisan hack? Play against type. So it does happen, and you see it on certain issues with certain justices.
All right, Dan, thank you so much for taking the time to join us and help break it down. We appreciate it as always.
My pleasure.